Thanks for joining this episode of our webinar series on best practices in eDiscovery, generative AI, and digital forensics. Today's session is focused on a topic that is creating a lot of challenges for the courts and in the eDiscovery process. Hyperlinked files and messages and other documents are frequently referred to as modern attachments. With the emergence of collaboration platforms like Slack and Teams over the past 10 years, the prevalence of hyperlinked files has skyrocketed. They've created several challenges that span the electronic discovery reference model, including addressing these file types in ESI protocols, collecting these documents in digital forensics, and locating the documents, including the parent-child relationship, in large data sets. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexby, and I'll be the moderator for today's event. Our guest speaker today will elaborate on all these issues, provide the notable case law rulings, and equip you with the best practices that you'll need to handle hyperlinked files. In addition, we'll provide you with resources at the end, including a link to Craig Ball's annotated ESI protocol, which also covers hyperlinked documents. We've got a lot to cover, so I'll get started. Our webinars take place monthly and cover a variety of relevant eDiscovery, artificial intelligence, and digital forensic topics, trends, best practices, and strategies. We've got limited seating, so be sure to register early for the sessions that are of interest to you. If you have technical issues or questions, please email us at webinars@lexby.com and we'll address them right away. Our webinars are available online at lexby.com for viewing via streaming video, or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com or on our YouTube channel. If you have any questions during today's session, please enter them in the Q&A portion of the GoToWebinar console, and we'll answer them after the event. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn, and subscribe to our YouTube channel. For more than 18 years, Lexby's been helping legal teams handle document-intensive matters. We have the industry's most affordable and full-featured DIY cloud-based eDiscovery platform. This includes over 7 AI algorithms that assist our clients with their cases. This also includes Lexby Copilot Generative AI that automatically summarizes documents, creates case timelines, translates foreign languages, identifies hyperlinked files, performs entity detection, provides sentiment analysis, and will analyze documents for responsiveness with a confidence score and the rationale. We also have the industry's fastest eDiscovery processing and document review platform. We deliver the industry's fastest return on investment per a study that was done by G2. We're also rated as the eDiscovery company that's the easiest to do business with, a high performer, and the easiest to administer. In addition, we have a state-of-the-art forensic lab staffed with Cellebrite certified and Magnet Axiom certified forensic investigators who perform full and targeted forensic collections. We're also a Metaspike partner and perform forensic collections of hyperlinked files for our customers' cases. If you'd like a demonstration of our platform or would like a complimentary forensic consultation, simply email us at sales@lexby.com and we'll get that scheduled for you. Joining us today is Doug Austin. I'm going to let Doug introduce himself and eDiscovery today, but before I turn it over to Doug, I'd like to ask for your participation in a couple of polling questions. And our first polling question is, are you seeing an increase in the number of hyperlinked files in the ESI for your cases? And while you're answering that, I'd like to thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And our next question, have you utilized generative AI to analyze documents and locate hyperlinked files? All right, and I'll go ahead and close that poll. And without further ado, I'll turn it over to Doug Austin. Doug?
Thanks, Jeff, and welcome everybody to the Lexby webinar, What You Need to Know About Hyperlinked Files in eDiscovery, Considerations and Best Practices. I'm excited to be presenting here today and hope you find the discussion informative as we tackle a very challenging topic in eDiscovery today. A little bit about me before we get started. I've been managing litigation support and eDiscovery projects for over 30 years in the industry, so I've stayed up on eDiscovery trends and best practices. Additionally, I've been publishing a daily blog for over 14 years, so I'm either committed or I ought to be. Seriously, though, writing daily has also forced me to stay current with eDiscovery trends, including the one here we're here to discuss today about hyperlinked files. You can stay up with these trends by reading or subscribing to eDiscoveryToday.com. Subscribing will also get you free access to any reports published by eDiscovery Today, including the annual State of the Industry report. Before we begin, I always remind people that any ideas expressed by me here today are my own, not those of my organization, clients, or partners. Also, please don't consider anything I'm saying legal advice. It's eDiscovery best practices advice. That's my standard disclaimer. For this one, I'll add two others. This is a topic where things are changing rapidly in terms of the case law and the technology, so please keep that in mind that what we'll be discussing is the current state of the hyperlinked files issue in eDiscovery, and that some of these trends will likely change and probably change quickly. There will be new case law rulings that may have impact and new technological changes and capabilities that may also impact how hyperlinked files are handled in the future. Also, this is a topic that has generated strong differing opinions as to how these files should be handled and even what they should be called. These opinions tend to line up remarkably along which side of the V people normally work on. I've tried to look at the topic from a balanced perspective of both requesting and producing parties, which means that each side naturally disagrees with some of my assumptions and statements. So I encourage you to do your own homework and make your own decisions regarding the issue of hyperlinked files and what party can and should do to address them in discovery. So here's what we'll be covering today. We'll start by discussing why we're here in the first place. What's the big deal associated with hyperlinked files, and why are they such a problem now when they didn't used to be? We'll also discuss how we can't even all agree on what they should be called and provide some thoughts and guidance there. We'll then address 5 assumptions about hyperlinked files that I identified that are designed to focus the discussion and get us all hopefully pointed in the same direction regarding that discussion. That will lead into a discussion about the notable case law rulings to date and what the courts are saying about the issue as these disputes have become more frequent. In fact, we just saw 3 case rulings in 5 weeks earlier this year on this issue. Then we'll get into the technology and discuss the current capabilities and challenges for collecting hyperlinked files, which everybody's talking about, and preserving them, which almost nobody's talking about. We'll follow that up by debunking a few myths, at least they're myths in my opinion, that exist regarding these files. Not everybody agrees that these are myths, but again, I will provide my own perspectives and encourage you to do your own homework on the topic. Then we'll briefly discuss recommendations and best practices from each point of view, requesting and producing parties, and how to prepare for the inevitable disputes to come. We'll conclude with what I think the future holds and whether this issue is going to get better anytime soon. And we'll also touch on a resources slide with links to resources for more information. And there's also, in addition to those, there's also links in various slides throughout for you to check out when you get a copy of the slides. So what is the big deal with these hyperlinks? Haven't we had hyperlinks in emails forever? Yes, we have. We've had hyperlinks to web pages, to folders, and to files for about as long as we've had email itself. This is nothing new. However, most of the files that we've sent via email over the years have been sent as physical attachments to the email. This reflects the fact that we were all operating back then in an on-premise world before the cloud, where our email and work product files were located on-premise. So that was the best way, and often the only way, to share files with colleagues in different offices or even different organizations. Because physical attachments were so common to emails, eDiscovery solutions like Lexby developed workflows to treat the emails and the physical attachments as what we call a family group, where the email was the parent and the attachments were the children. These workflows automated the processing and association of the email and its attachments, and the ability to produce these email families became a standard expectation in discovery. The biggest advantage of the use of physical attachments was that a snapshot of the attached files were saved when the email was sent, so no matter what happened to the file or files afterwards, your snapshot was saved. However, in the past several years, organizations have been moving to the cloud, and much of what we do today happens there, especially as remote and hybrid work has become more common. As a result, people and organizations have begun linking to files stored in the cloud instead of embedding them physically as attachments. In some cases, organizations encourage the practice. In others, they even require it if the file to be attached exceeds a file size limit that they've set up. This trend is great from a records management and information governance perspective because it reduces data redundancy. You no longer have multiple copies of the same file in different recipients' inboxes, which improves data hygiene. But this trend absolutely sucks for eDiscovery professionals because we no longer have a snapshot of these files when they were sent. We just have a link to that file. Over time, it may be difficult to get to the version of that file which was sent, as that version may no longer even exist. It may be difficult to even get to the file at all if it's been deleted or if access rights to it have been revoked. The file no longer being embedded in the email makes discovery of that file much more difficult at best and downright impossible at worst. So here's an illustration of the difference. This is what an email looks like with an embedded attachment. As you can see, it's an email that contains a blog post that I wrote that's been physically attached to the email. Even if I subsequently delete the Word document containing the blog post, it will still exist as a physical attachment to this email, which means that it's still available for discovery if my emails are being preserved and collected. This is what an email looks like with a hyperlinked document. It's the same blog post as the previous email, but now you have to go retrieve the file using the link to my OneDrive repository. If that file is subsequently changed, deleted, or the access rights to it are taken away, you can't get to that file, or at least the exact version of the file that existed at the time the email was sent. That's why hyperlinked files are beginning to create considerable havoc for eDiscovery professionals, and there's a lot of disagreement on how these files should be handled in discovery. In fact, we can't even agree on what to call these things. Should we call them pointers or hyperlinks, or hyperlinked content? Some people think this issue pertains to anything that can be hyperlinked. Or are they more specifically hyperlinked documents or hyperlinked files? Some people think this issue just pertains to those and not to just anything hyperlinked. Or should we call them cloud attachments, which is what Microsoft calls them? Microsoft certainly has a lot of influence in matters like this, so you certainly can't discount that. Or should we call them modern attachments, which is a term that many requesting parties like to use because they want to see them treated the same as physical attachments with the email and the linked file produced as a family. On the flip side, producing parties hate this term because they don't want to see them treated the same as physical attachments, as it drives up discovery time, effort, and cost considerably to try to do so. So here's what you should call them. Ready? It doesn't matter what you call them, at least within reason. I mean, look, we're an industry that can't even agree on how to spell eDiscovery, so I certainly don't think we're going to reach consensus on this, and that's okay. If you want to call them attachments, go ahead. If you think they shouldn't be called attachments, that's fine too. It doesn't matter what you call them, it matters how you consider them. They are part of information that's being communicated in a message to one or more other parties. As Judge Cisneros said in the Uber case that I'll cover in a bit, they go to who knew what when. That's potential evidence. Communications are almost always important and potentially responsive in litigation. So that makes the file being linked potentially responsive as well. Now, that doesn't mean they necessarily have to be produced, because proportionality factors into that. So if you say they're not attachments, fine. If you say they're not potentially responsive, I would disagree with you on that. Now, I prefer to call them hyperlinked files, and of course, as I noted, not everyone agrees with that, so I'll address that on the next slide. So it's been over a year since I published my first post on hyperlinked files on August 28th of last year, which was a post about the case law to date at that point. I then asked the question, are they modern attachments on LinkedIn, and tagged a bunch of people. And the debate blew up with a lot of disagreement as to what they should be called and how they should be handled. And the discussion was all over the place, with people saying things like, well, what about a link to a website? Or we may not even have possession of the files, or the files may not even exist. So I decided to publish a follow-up post of 5 assumptions that I hoped we could all agree on to focus the discussion. So here they are. The first one is that we're talking about hyperlinked files, not all hyperlinks. Some people say, no, it's all hyperlinked content, but I disagree, and here's why. As I mentioned, hyperlinks have existed in emails for almost as long as there have been emails. We've been linking to hyperlinks, folders, and files for decades. This was never a problem before because it was occasional and typically handled on a case-by-case basis. If you produced an email with a link to content the requesting party couldn't get to, they would typically reach out and request it, and you would either produce it or meet and confer about it. So why is it such a problem now? Because the frequency in which files are hyperlinked instead of embedded has gone way up and is rapidly becoming a standard because of the move by organizations to the cloud and the ability to cut down on redundant files by linking to them instead of embedding them. So that's why I say the issue is about hyperlinked files, not all hyperlinks. The frequency of hyperlinks to other types of content hasn't really changed materially. Now, if you want to boil the ocean and go after everything, be my guest, but the files are plenty enough of a challenge for me. Second, the files must be in your possession, custody, or control. This is a standard eDiscovery expectation, and it's addressed in FRCP Rule 34. And here's a scenario where that can play out. Let's say that Adam, Brenda, and Carol are with 3 different companies, and they're working on a potential partnership plan. So Adam creates a document in Google Docs and shares it with Brenda and Carol via a link in an email. That's a hyperlinked file, and they all proceed to collaborate on the content for the document, which is how businesses are working more and more today. Now let's say they have a falling out, and Adam removes access to the file for Brenda and Carol. Then Brenda sues Carol, but not Adam. Brenda requests correspondence from Carol that occurred between the 3 parties. Carol can produce the emails, but not the file linked because it's on her possession, custody, or control. Brenda would have to request that directly from Adam in a non-party subpoena. So guess what we're going to see a lot more of? Non-party subpoenas, because the files that used to be embedded in emails are now hyperlinked, and they may be in the possession, custody, and control of another party or non-party. So you may have to get it from those non-parties when that's the case. Third is, you can't produce a file that isn't there. Duh, right? But it's an important concept to recognize. Files that are linked within messages will disappear during the normal course of business and through retention and destruction programs. And there's nothing you can do about that. Now, once there's a duty to preserve, that's different, though the preservation of these files isn't necessarily straightforward, which I'll get to in a bit. Regardless, parties in litigation must accept that the file being linked may no longer be there, and they've got to be prepared to deal with that. Fourth is that hyperlinked files should still be produced if they're deemed to be responsive. Wait, you may be saying, that means I'd have to produce them as a modern attachment? Not necessarily. What that means is that regardless of how difficult it is to produce them as part of a family with the message, you should still be searching the data locations of custodians and produce files from them independently if they're responsive. In the on-prem days, we typically preserved and collected from a custodian's mail stores, local drive, and personal network share. Those sources are typically mostly all in the cloud now, but they're still just as responsive. A producing party may not be obligated to put the pieces of the puzzle together, but that party should still produce those pieces if they are independently responsive. Finally, of course, discovery of hyperlinked files must be both relevant and proportional. That's also part of the rules of our CP Rule 26b1. Of course, as it is for many other types of ESI, getting the parties to agree on what's relevant and whether the burden exceeds the benefit is challenging. Proportionality of ESI is a common dispute, and it's certainly not limited by this issue. Regardless, it's important to recognize that the burden of producing these files is currently significant, which we've seen discussed in the case law. At the bottom is the link to my blog post discussing the 5 assumptions, which you can check out on your own. So we're seeing more and more relevant case law decisions related to this issue, and they're beginning to occur with greater frequency. Here's a list of notable case law rulings to date. Several of these I'll be discussing on the next few slides. One case that I don't have a slide for is the first case, which tends to be a forgotten case in these discussions. In that case, the special master ruled that the defendant needed to produce 2,200 linked files in Google Docs with the emails that linked to them. The phrase modern attachments wasn't bandied about in that one, but the defendant was essentially ordered to treat them like modern attachments. Not only that, the defendant was also ordered to provide information regarding any of those files that were deleted to illustrate that they were deleted in the ordinary course of business and not once there was a preservation obligation. I also don't have a slide for the last file on this list, but we'll mention it at the end of the case law discussion. Both of these cases are linked to within the resources slide at the end of the slide deck. The others, which I'll cover in the next few slides, will be linked to at the top of each slide. So here's the first case that most people know about regarding hyperlinked documents, Nichols v. Noon. In this case, the plaintiffs didn't anticipate there would be hyperlinked documents and didn't realize there were until they started receiving productions where the emails had links instead of embedded attachments. This was well after the parties had already negotiated and agreed upon an ESI protocol, which didn't address the potential issue of hyperlinked files. The plaintiffs pushed for hyperlinks to be treated as modern attachments and produced as part of a document family, and for the defendants to reproduce the emails accordingly. The defendants argued that hyperlinked files are not attachments, noting that they were separately collecting and producing relevant internal documents from Google Drive. However, they did agree to produce a reasonable number of linked files at the plaintiff's request. In this case, Judge Parker observed that the ESI protocol did not specifically address hyperlinked documents as part of family groups, and she ruled that they were not attachments and that they may or may not be necessary to the communication. The next case, the Metapixel case, was the first notable case ruling to be decided before there was an ESI protocol agreed upon. In fact, this issue was one of the sticking points to agreeing upon an ESI protocol. Here, Judge DeMarchi stated that she was persuaded that the commercially available tools suggested by the plaintiffs were not sufficient for use by Meta in their environments or systems and wouldn't work with their workflow. So she ruled that hyperlinked documents should not be treated as conventional attachments. But she also stated that the parties should consider reasonable requests for them on a case-by-case basis, and that such requests should not be made a matter of routine. While this was a notable ruling, there wasn't much analysis included in the case ruling itself. In fact, the second and third bullet points are the entirety of what the court ruled on this issue. So the lack of analysis makes it difficult to understand exactly what options were considered to address this issue and exactly where the burden existed. Almost 11 months later, this case ruling involved a different look at the issues. Like the Metapixel case before, Judge Cisneros was addressing an issue between the parties as part of agreeing to an ESI protocol. Unlike that case, however, she conducted a fairly in-depth analysis of the issues. She discussed the issues with Google Vault and how it doesn't keep track of the versions of hyperlinked documents sent, which she referred to as the contemporaneous versions, which is, by the way, a term I like as a way to refer to them. But she also noted that the contemporaneous versions of hyperlinked documents can support an inference regarding who knew what when, and recognize the potential evidentiary importance that they have. So she ruled that Uber should preserve the metadata relationship between emails and linked files to the extent possible, and included modern attachments in the definition of attachments to be included in the ESI protocol, as you can see on the right-hand side of the screen. But she also recognized the technological difficulties of producing them and noted that Uber is not obligated to produce them if the technology doesn't make it feasible. Of all the cases so far, this is probably the best one in terms of discussing all the issues and considerations associated with hyperlinked files. This next case had two rulings, the first of which was last year. As you can see by the first bullet point, the parties had already agreed to an ESI protocol, which said that hyperlinked files must be produced as separate attached documents. When StubHub encountered difficulties doing so, Judge Hickson called them to task for it, saying things like, litigants should figure out what they're able to do before they enter into an agreement to do something, and that litigants should live up to their agreements, especially when they're embodied in court orders, which the ESI protocol was. Because StubHub not only had failed to produce the files, but also failed to really provide an adequate explanation as to why they couldn't, they were ordered to either produce the files or provide a 30b6 witness to explain why they couldn't. They agreed to the provision before doing their homework to realize just how difficult it was to do so. Big mistake. However, they wouldn't pay for that mistake indefinitely. About 13 months later, Judge Hickson revisited the issue after StubHub finally did make it clear just how difficult producing these files were, and after they submitted to that 30v6 deposition. So Judge Hickson noted that the ESI protocol stated that it may be modified for good cause, to which he found that StubHub had demonstrated good cause to remove the requirement that hyperlinked documents should be produced as attachments. He also discussed some of the current limitations of available software and noted that the lack of software that can handle the hyperlinks was a strong reason to modify the ESI order. So he removed the words hyperlinks to internal or non-public documents from the definition of attachments. Now, 8 days later, in the in-ray insulin pricing litigation, Judge Singh in that case also agreed with defendants and ruled that hyperlinks are not the same as traditional attachments, adopting the defendant's proposed language for the ESI protocol in that case, which relied in part on the StubHub ruling just 8 days earlier. With 3 case law rulings in about 5 weeks' time, the issue is certainly heating up. Now let's discuss the current technological landscape, starting with collection. And we'll begin that discussion with the source ESI systems, primarily M365 and Google. The good news is that M365 and Purview have had a cloud attachment collection feature for a couple of years, which will not only collect the current version of the document, but it will also collect all versions of the document if requested. Of course, most people don't need all the versions of a document, they just need the contemporaneous version, so this approach causes a lot of additional work to find the right version of the file, and can also create considerable overhead by making export of so much more data associated with all those versions grind to a halt. Recently, Microsoft has added the ability to mark the version shared at the time it was sent, which can streamline these issues, but you have to set it up beforehand in the compliance module, and it doesn't apply to any versions sent before you turn on that tracking. Litigation tends to be about files from the past, so it may take a few months before we start seeing some cases involving files that can take advantage of this feature. The other issue is that you need an E5 license to be able to use the feature. However, there is one thing about that. That doesn't necessarily mean you have to have a full E5 license. There are various sublevels of E5 licensing you can add. To add the capabilities that you would need for cloud collection, you can add a Microsoft 365 E5 compliance license as an add-on subscription to your licensing plan instead for $12 per month per user. That can save as much as $26 per user per month for small business plans and $9 per user per month for enterprise plans. For an organization of 50,000 users, an E3 license plus a Microsoft 365 E5 compliance license could save an organization as much as $5 million per year over a full E5 license. Of course, keep in mind that Microsoft frequently changes its pricing plans, so this is how it currently works today. The key is to investigate all your pricing options to pick the plan that's right for your organization. As for Google, back in December, they added the ability for an admin to automate the export hyperlinks of Google Drive content from Gmail messages. That's a good first step, but the problem is that they don't track the versions of the files, so the only version you can export is the current version. You often don't know whether that's the contemporaneous version and couldn't get back to it if you did know. Now, most of the cases so far have dealt with either M365 or Google. In the StubHub case, they used a mixed solution, Microsoft emails accessing Google Drive documents, which adds another layer of complexity to the issue. But there are also plenty of other systems which have the same potential issue of messages of hyperlinks to files, including collaboration apps like Slack and Teams and many more. So you need to be aware of the platforms you or your opponent uses and how they currently handle hyperlinked files. You'll notice I have a single bullet point for eDiscovery solutions with Metaspike's forensic email collector listed as one of the examples because the use of it has been part of the discussion in several of the cases we've seen so far. Requesting parties have been proposing it as a solution to reduce the collection burden, while producing parties have been saying it's not good enough. Here's the thing, regardless how good it is, or any eDiscovery solution is, they can only go so far. You can't collect what isn't there, and in many cases, the files aren't there to collect, or at least the contemporaneous version of the files aren't there to collect. That's why there isn't an eDiscovery-only solution to this problem. It has to come, at least mostly, from the source ESI systems to make the files available for us to preserve and collect. So a lot of people have been talking about the collection challenges. Practically nobody is talking about the preservation nightmare of hyperlinked files. So let's walk through a scenario to illustrate it. Let's say you have a custodian named Sarah Davis, which is the name of the custodian Microsoft uses in their Add Custodians to a Case help documentation that I reference in my preservation nightmare post linked in the resources slide at the end of this presentation. She has email, which of course you want to preserve, and she also has files in her Teams, SharePoint, and OneDrive data locations. Microsoft says you can identify the custodians, choose the custodian data locations, and configure hold settings and effectively issue a legal hold in place, which is supposed to be one of the benefits of cloud-based solutions. We do that and put those data locations on hold for Sarah Davis. Good to go, right? Not exactly. Here's the problem. When you do that, you're only putting the files that she sent via email on hold. She's interacting with a whole bunch of other people that may be in the organization or outside of the organization. They may be, in this case, 16 other people who are sending links to files to her from their own data locations, and it's usually way more people than that custodians are communicating and collaborating with. So, unfortunately, none of those are being put on hold when you put her data locations on hold. So, to effectively put her files on hold, you would have to put each of these data locations on hold, which begins to multiply the more custodians you have, and essentially becomes impractical as it would paralyze an organization's entire enterprise and information governance program. So how do you ensure a full hold? Right now, you would have to do so by preserving, by collecting, including the linked files and the other custodians' data locations, which basically negates the benefit of in-place preservation. So that's the preservation nightmare associated with hyperlinked files. If you're a requesting party, you may need to be prepared for the fact that not every file associated with a custodian may be on hold, which means you may want to consider negotiating for additional custodians or at least raising the issue and meet and confer. If you're a producing party, you need to be prepared to defend whatever approach you take for preservation, which should include proactively raising the issue early in the case. Courts may not appreciate the knowing failure to preserve certain data, even if it is more difficult to preserve than ever before. So earlier I talked about 5 assumptions we can make about hyperlinked files. So now let's do some myth busting, where we'll bust 6 myths that some people believe about them. The first myth is that you can always tell whether a linked file may be responsive based on the email. No, you can't. Emails that link to files can contain almost no useful information to determine responsiveness. Many times after a meeting or a phone call, I've sent an email to the participants in that meeting or call with a link to a file that simply says, as discussed, in the body of the email. Many people do that at some point. Good luck figuring out whether those communications are responsive just based on the email. One big concern I have with rulings that specify that the requesting party may request the linked file for selected emails is that they often don't have enough information to know whether the email may be responsive. Often the important information that determines responsiveness is all in the linked file, which makes that really difficult when you don't have that. The next myth is that the tools exist today to fully support treating hyperlinked files as modern attachments? No, they don't. There have been plenty of limitations that have been identified with existing platforms, especially when it comes to contemporaneous versions of linked files. M365 is probably the closest to being able to do it, and it still has limitations, especially on the preservation side of things. While I do think that there may be solutions to help address part of the challenge, especially if the file hasn't been changed since the link was sent in an email or other communication, I believe the people who say we can't fully support the need with any tool or combination of tools today. We're just not there yet. Next is that case law ruling decisions based on burden of discovery will have long-term precedent. No, they won't. The last two cases on the list both decided that hyperlinked files should not be treated as modern attachments. Does that set a precedent? No. Why not? Because the decision in both cases was based on the ability to treat the hyperlinked files as attachments and the burden of doing so. Guess what? The capability of the tools and the associated burden will evolve over time, and I expect they'll be able to much more fully support the need to retrieve hyperlinked files than they do now. Unless a specific court is short-sighted and fails to take into account the evolution of technology, each court ruling will be based on the technology capabilities available at the time the issue is before the court. Just because the handling of hyperlinked documents isn't proportional today doesn't mean it won't be down the road. The next one is that an eDiscovery solution will solve the entire modern attachments issue. No, it won't. No matter how good an eDiscovery solution gets at collecting ESI from source solutions, it will never solve the entire modern attachment solution alone. Why? Because you can't collect what isn't there. An eDiscovery solution can't collect contemporaneous files if the source application isn't preserving them and making them available to be collected. The solution that reportedly comes the close currently is Forensic Email Collector from Metaspike. It can do a lot in terms of automating the collection of linked files within emails, but it can't collect the contemporaneous files if they don't exist. No matter how good the eDiscovery solution is, it will need help from the source ESI application to make available what needs to be collected. It can't solve the entire issue alone. On the flip side is that the source ESI apps won't implement enhancements to help address the problem. Yes, they will. In fact, they're already doing that. We're already seeing app providers enhance their platforms to address these needs. Last December, Google announced the ability to export hyperlinked Google Drive content from Gmail messages. And Microsoft Purview eDiscovery Premium does support the ability to collect what it calls cloud attachments. To be sure, both capabilities are limited and can't support everything users need yet. But the first step to addressing a problem is recognizing that you have a problem. Both Microsoft and Google have done that and will do more, and others will follow suit. Last is the myth that we won't have to find a solution for this problem. Yes, we will. Why? Well, do you think litigation is the only reason we need this capability? There are other use cases, such as investigations, HSR second requests, and incident response, where the ability to get back to the linked files will be important. In fact, it's my understanding from folks that the FTC has added this sentence to their production requests. Hyperlinked attachments/documents should be treated as normal attachments and therefore produced with family identifying metadata accordingly. You're not going to get very far making a burden argument with the FTC. The need is going to be there to address the problem. This isn't an issue where you can stick your head in the sand and hope that it goes away. So with that said, let's talk about best practices. We'll take a look at these best practices from each point of view, starting with requesting parties and then addressing them for producing parties. So the first best practice for requesting parties is to learn about your opponent's ESI sources as early as possible. Doing so enables you to understand the capabilities that your opponents have regarding preservation and collection of the data. That will help you in negotiations in terms of knowing what they should be able to do and what their platforms may keep them from doing, such as preserving all of the custodian's set of data. The next one is to understand preservation challenges and to address preservation strategy with your opponent. Now that you know that there are some limitations in platforms like Microsoft 365 and Microsoft Purview, you need to raise those with your opponent and understand how they'll preserve that data. This includes raising it in any preservation letters you send to your opponent, as long as you're often doing so before the case is even filed. You also need to plan for increased non-party subpoenas to complete the puzzle of hyperlinked documents that are not in the possession, custody, or control of your opponent. That includes issuing the subpoena promptly as soon as you know the data is needed, and being prepared to make an argument for production of the data if the non-party seeks to quash the subpoena. You'll need to demonstrate that just because the opponent has produced the email that you seek from the non-party doesn't mean the email is complete, and that you need the hyperlinked file from the non-party to complete the puzzle of who knew what when. You also need to address the need for your opponent to search document locations of its custodians and produce ESI that's responsive, regardless of the ability to link those files to emails and messages. It may be burdensome to produce them as modern attachments, but it shouldn't be burdensome to produce them independently, and you should push your opponents to do so. The next one is to pick your battles and focus on getting as much of the critical data you need as possible. There will be some data that's simply not available to get, and there's nothing you can do about that. You need to identify what data is most important to your case, request that as early as possible, and be prepared to demonstrate the value of that data when your opponent tries to assert a burden argument against having to produce it. The benefit has to outweigh the burden for it to be proportional, so be prepared to make an argument as to the benefit of that data that is as specific as possible. Finally, you need to stay current with the technological challenges and capabilities associated with discovery of hyperlinked files. The challenges will keep evolving, as will the capabilities of the platforms to provide the data. Keep yourself educated regarding how those challenges and capabilities evolve. What's burdensome today may not be burdensome tomorrow. So now it's the producing party's turn. So here are some of some best practices from their perspective. First, you need to understand your technological capabilities and challenges before agreeing to anything. This is what StubHub failed to do when they agreed to an ESI protocol that called for hyperlinked files to be treated as modern attachments. Fortunately for them, the ESI protocol included a provision to enable the protocol to be modified for good cause, such as the inability to satisfy a requirement. But it cost them a lot of money and time to address that with opposing counsel in the court that they wouldn't have had to spend if they already knew up front that they were unable to produce those files as modern attachments. Don't make the same mistake. Next, be prepared to address preservation challenges and vulnerabilities like the one I demonstrated with M365. You don't want to pretend they're not there and hope the opponent isn't educated enough to be aware of these potential preservation shortcomings. Preservation is not an area where it's better to ask for forgiveness than permission. You may need to prepare an argument regarding the reasonableness of preserving specific data that the platform doesn't automatically preserve, but it's better to be prepared to do that up front as opposed to doing so after your opponent finds out that the data has been spoliated. You can't count on the court to be understanding in that situation. Next, be prepared to provide specificity in your burden arguments. FRCP Rule 34B2B requires parties to state their objections with specificity as to the reasons they object. Objections such as overly broad, unduly burdensome, disproportionate to the needs of the case, and not reasonably calculated to lead to the discovery of admissible evidence are considered boilerplate objections, and courts are increasingly finding these objections are waived. Parties no longer get a second chance to object when using boilerplate objections. You'll need to provide specificity to make an effective burden argument. You also shouldn't rely on case law precedents to bail you out from having to produce hyperlinked files. While there have been several courts that have ruled that hyperlinked files don't have to be produced as modern attachments, those rulings were based on the technological capabilities available at the time. Because those capabilities will evolve, future cases will depend on the capabilities available at that time, which may be more robust than they currently are today. Next is to maximize the technological capabilities that you do have. You're under no obligation to go get technology to enable you to produce hyperlinked files as modern attachments. So, for example, if you have an E3 license of M365, you're not obligated to spend more money to move to the E5 license. But if you already have an E5 license, you should be expected to use its capabilities to the fullest to respond to those requests. Courts are less likely to be sympathetic if you have the technology which can help, but you're not using it. And finally, understand that you still need to develop the best approach possible to support other eDiscovery use cases like government investigations. As I mentioned earlier, the FTC is now requiring parties to treat hyperlinked files like normal attachments. Nobody ever plans to be investigated by the government, but since the possibility exists, it's best to be prepared with an approach to respond to situations like government investigations, including HSR second requests for mergers and acquisitions. Those possibilities can exist, and you should be ready for them. Okay, so what does the future hold for the issue of hyperlinked files? So the first thing that I expect to happen is to see continued disputes over the contemporaneous version of the file and whether the producing party is obligated to provide or to produce the current version or best version available if the contemporaneous version isn't available. I expect requesting parties will push for whatever version they can get, while producing parties will try to make a case that any version other than the contemporaneous version doesn't accurately illustrate who knew what when. I would love to see a court ruling over this issue, and hopefully we'll see one soon. The next thing that the future may hold is the death of the custodian in terms of eDiscovery preservation and collection. We're beginning to see a disconnect between how cloud-based platforms store data in an increasingly very decentralized manner and the expectation that you can still get to all the data associated with a given custodian for preservation and collection. It's interesting that M365 provides the ability to put a custodian on hold by adding them to a case without all the data associated with the custodian actually being put on hold. It seems that cloud-based solutions like M365 are getting further and further away from the custodian concept in terms of how the data is stored. So this could eventually lead to a different approach for in-place preservation, where perhaps potentially responsive data is identified, perhaps through searching, regardless where it's located, and preserved in place across the enterprise instead of for specific custodians. I think that could eventually happen, and it might even happen sooner than we think. The next thing that will happen, and in fact is already happening, is frequent changes in the technology. Those frequent changes are happening and will happen in the ESI source solutions that need to provide a way to get to the hyperlinked files for preservation and collection. Take M365 and Purview, for instance. Every month, Microsoft puts out a roadmap of updates that it makes to its products. Many of those updates relate to eDiscovery functionality within M365 and Purview. Greg Buckles captures the monthly M365 roadmap updates and publishes them on his excellent eDiscovery Journal site at eDiscoveryJournal.com. I recommend you keep up with those updates, as Microsoft doesn't keep their roadmap updates posted for very long. To give you a sense of just how many updates happen in a given month, Greg's post for August 2024 shows 327 updates that are either in development, rolling out, or already launched, just related to eDiscovery. So it's important to keep up with updates to relevant technology solutions so that you're aware of the latest capabilities of these products in terms of how they handle hyperlinked files. So remember when I said that eDiscovery platforms won't solve the entire hyperlinked files issue? That's true, but solutions that may do so, or at least help address the challenge, are data archiving solutions. I know of at least 2 solutions that are currently working on journaling and capturing hyperlinked files as they're sent in emails and other messages. Doing so could enable organizations to get back to the contemporaneous versions of hyperlinked files that might otherwise become unavailable over time. Data archiving provides several benefits to organizations, and adding this capability could enable these solutions to fill the gap that's currently being left by cloud-based source ESI solutions. Another trend I expect to see is case law rulings where the dispute over hyperlinked files relates to collaboration solutions instead of email-based solutions. All of the case law rulings that I'm currently aware of have dealt with discovery of hyperlinked files for emails in M365 and Google Suite. Just as we've begun to see more case law dealing with general issues associated with collaboration apps like Slack and Microsoft Teams, I would expect that we'll begin to see disputes related to hyperlinked files for those platforms and others as well. So it will be important to understand how these collaboration solutions currently handle hyperlinked files as well, and the solutions will probably also have to consider applying updates to support this requirement in discovery. So the final item on the list is what I say is more of a wish list item than a prediction. There's a concept known as eDiscovery by design, where the developers of the platforms can consider potential needs for eDiscovery as part of the design of those platforms. If these developers did so up front, we wouldn't be in the mess we're currently in. It would be great if these platforms would consider how the ESI will be produced during the design and development of their platforms, but those eDiscovery needs are typically an afterthought at best. Ultimately, these platforms then eventually have to scramble to add features to support the needs of legal and eDiscovery professionals, typically only after they receive the request from enough of their users to prioritize those enhancements. My dream is that someday these software developers will consider eDiscovery needs up front instead of an afterthought downstream. I can dream, right? So here are some additional resources you can check out on your own. Very quickly, the first bullet point and the sixth bullet point are posts about the two cases that I didn't cover in depth in this presentation. Each has a link to the actual case where you can review the full case ruling itself. Bullet points 2 and 3 are posts from me regarding current trends related to hyperlinked files and my prediction as to what will happen with them in the future. Bullet points 4 and 5 are blog posts from expert Craig Ball in his excellent Ball in Your Court blog, where he provides his own discussion about hyperlinked files and his contention that they should be called modern attachments, or at least cloud attachments, which is what Microsoft calls them. The seventh bullet point is my write-up about the preservation nightmare of hyperlinked files, which also links to the Microsoft documentation about how to add custodians to a case and apply legal hold to their email and data locations, but not, as I discussed previously, hyperlinked files that were sent to them. And finally, the last bullet point covers a discussion that Tom O'Connor and I had with John Collins of Lighthouse, who provided a lot of useful information regarding M365's eDiscovery capabilities that were referenced in this presentation. You can also go to eDiscoverytoday.com at any time and search for the term hyperlinked files to see any of the posts I've written and what the latest trends are that I've been seeing. Hopefully this discussion has been helpful to you, and these resources will be as well once you receive the slides. So with that, I will say thanks to all of you for attending, and I'll turn it back over to Jeff to close us out.
Thanks, Doug. That was a great presentation. When it comes to gaining access to hyperlinked files for your case, it's important to start with your custodian data mapping and ESI protocol. Craig Ball does a great job with his annotated ESI protocol, which includes a section on hyperlinked documents. I highly recommend you visit craigball.com and see the link there for his annotated ESI protocol. It's a great resource for you to have at your fingertips to address this issue. When you're ready for evidence acquisition, it's important to perform the digital forensic collections with the proper method and tools to collect the hyperlinked files. As I mentioned in the introduction, we have an advanced forensic lab with the latest tools to help collect the documents you need for your cases, including the hyperlinked files. We can detect and acquire hyperlinked attachments from Google Drive, as well as Microsoft Exchange and Office 365. We're a Metaspike digital forensics partner and utilize their tools to help acquire hyperlinked files. Lexby's digital forensic investigators perform remote and on-site collections and have performed collections from all kinds of sources, as you can see on this partial list. If you need to find deleted text messages, hyperlinked files, or collect data from sources like Slack or Microsoft Teams, then we're here to help. And this leads me to our next polling question. Do you have a digital forensic project, and would you like a complimentary consultation? If you're looking for all of the hyperlinked files in your case, it's easy with the Lexby eDiscovery platform. The best practices that we recommend include filter by file type, and in this example, I filtered by .msg. It can also be beneficial to filter by custodian to narrow the scope of the files that you're looking for. Then you can click on the star icon that I've circled in red on the screenshot, and you'll get a pop-up window asking you to create a prompt. Here you'll instruct the GenAI large language model to analyze the selected documents and provide a list of the hyperlinked documents that includes the parent-child relationship. Then Lexby Copilot will create a list of all the hyperlinked files of the corresponding parent. When Lexby processes ESI into the Lexby eDiscovery platform, we retain all of the links so you'll be able to access the documents unless they're password protected or require authentication for access. So here are some best practices for locating hyperlinked files in your ESI. First, filter by file type, date range, and custodian to help narrow in on the exact files that you're looking for. Assign a persona to the GenAI large language model when crafting the prompt to leverage expert pattern recognition. So you'll want to instruct the GenAI LLM to act like an expert forensic investigator, which will hone its analysis to the corresponding persona pattern recognition. To prevent a lot of non-document hyperlinks returning in the results, you'll want to define the document types you're looking for in the prompt. You'll also want to give the GenAI LLM instructions on how to format the output with the parent-child relationship, and you can include a summary as well. You'll always want to utilize a zero data retention API or plan to ensure that the LLM doesn't train on your case documents and doesn't retain your case documents. Lexby is an end-to-end eDiscovery platform that includes the Lexby Copilot GenAI feature. There are a multitude of applications for using Lexby Copilot, which includes easily summarizing documents, depositions, and transcripts. If you're getting ready for trial, Lexby Copilot can analyze the opposing counsel's previous closing argument transcripts and generate rebuttal strategies. Copilot will also analyze a document for responsiveness, give you a confidence score, and the rationale for the prediction. If you're dealing with an acronym-intensive case like in telecommunications, Lexby Copilot can define acronyms on the fly to accelerate your review. It's great at identifying key dates, search terms, entities, and more. It will also provide assistance in identifying PHI, PII, or PNI. PNI is proprietary network information. You can translate documents on the fly into the language of your choice. You can create a chronology of events with summaries, and much more. We work with a lot of litigators to help them solve their eDiscovery challenges. Jordan Hallett is a sophisticated litigator running a multi-office boutique firm. Most of his cases involve larger, well-funded opposition. With Lexby, he likes having the ChatGPT integration available at his fingertips, so he can quickly gain insights into the relevant case documents. Mario Petrocco needed a platform to get litigation ready and deal with a contract dispute. He utilized the Lexby eDiscovery platform to identify the relevant documents and equip outside counsel with exactly what they needed. And with that, I'll ask our last polling question. Would you like a 10-minute demonstration of the Lexby eDiscovery platform with Lexby Copilot GenAI? While you're answering that, I'd like to thank you for attending today's session. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of the Lexby eDiscovery webinar series. For notices of future live and on-demand webinars as part of this series, please email us at webinars@lexby.com or follow us on LinkedIn. We'd also like your advice regarding our webinar series. Please complete the survey at the end of today's session. It helps us continuously improve this program and cover the digital forensic and eDiscovery topics that are most relevant to you. And with that, I'd like to thank Doug Austin for presenting today, and thank you for attending. Be sure to follow Lexby on LinkedIn and subscribe to our YouTube channel so you'll be alerted to the latest podcast and webinar episodes. And watch your inbox for an invite to our next webinar on best practices in eDiscovery, Gen AI, and digital forensics. Take care.